The law of agency deals with the relationships between sellers and buyers and real estate licensees. Typically, we're talking about the managing broker, the one in charge. Let's first off define what is an agent. An agent simply means that a person has been hired to represent someone else in a real estate transaction, such as a seller or buyer client. There are two types of agents a licensee can be. A licensee being one who has received a real estate license. One type of agent one can be is called a special agent, which means that a person or a licensee represents someone in one time in one area. This is a typical situation of where a licensee represents a seller in selling their home. The licensee only represents the seller that one time on that one property. Whereas a general agency relationship is an ongoing relationship. This might be like a property manager representing an owner in several areas on an ongoing basis. That person will be classified as a general agent. Many times at closing, a seller, for example, cannot be there to sign the documents, and so the seller would like to have someone else step in and sign their name on all of the legal documents at closing. The seller can go ahead and agree with someone else to become what is called their attorney in fact, which is a title given to someone who has received a power of attorney. So if the seller has a friend who is willing to sign their name on those closing documents, the seller would give the friend what is called a power of attorney document that needs to be signed, which allows the friend to sign the seller's name. So the power of attorney is what authorizes someone to sign somebody else's name on their behalf. Someone who has the power of attorney is referred to or called an attorney in fact. The attorney in fact is simply the title given to someone who has this power of attorney. Let's next talk about how agency relationships can be created. Most agency relationships are created on an express basis, which means both parties will clearly state their intentions, such as when a licensee lists a seller's home for sale. The opposite of that would be an implied agency situation, which is created by a person's actions. Implied agency is not where you want to be in real estate. An implied agency would be where a licensee says to a buyer, "Stick with me, I'll be sure to get you the best deal in town." The licensee is implying that the licensee is going to represent the buyer, but in fact that may not be the case without a signed written buyer agency agreement. So expressed agreements is where licensees should always be, meaning that the agreements are in writing and both parties are clearly stating their intentions. A principal or client, those two terms are interchangeable, is the party that hires the agent. So the principal or client who does the hiring will give instructions, so forth and so on. The agent who is hired to represent that principal or client must follow instructions as long as they are legal instructions and must always do what is in the best interest of their client. The agent who is hired always has a fiduciary obligation to the principal or client, which means the agent must do what is in the client's best interest. Finally, dual agency is where a licensee represents both a seller and a buyer at the same time on the same transaction. Some states allow this, some states do not. But for the states that do allow dual agency, this must be agreed to by all parties right up front.